Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Johnson v. Arteaga-Martinez. In this case, the court considered this issue: is a non-citizen who has spent more than 6 months in immigration detention awaiting resolution of their deportation withholding claim entitled to a hearing before an immigration judge to determine whether they can be released on bond? The case was decided on June 13, 2022. The court held that Section 1231A(6) does not require the government to provide non-citizens detained for 6 months with bond hearings in which the government bears the burden of proving, by clear and convincing evidence, that a non-citizen poses a flight risk or a danger to the community. Justice Sotomayor delivered the opinion of the court, in which Chief Justice Roberts joined along with Justices Thomas, Alito, Kagan, Gorsuch, Kavanaugh, and Barrett. Justice Thomas filed a concurring opinion, in which Justice Gorsuch joined as to Part 1. Justice Breyer filed an opinion concurring in part and dissenting in part. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Sotomayor delivered the opinion of the court. Section 241A of the Immigration and Nationality Act, INA, codified at 8 U.S.C. Section 1231A, authorizes the detention of non-citizens who have been ordered removed from the United States. In particular, Section 1231A(6) provides that after a 90-day removal period, a non-citizen may be detained or may be released under terms of supervision. This court recently held that Section 1231A applies to individuals who are removed and who then re-enter without authorization and apply for withholding of removal based on a fear that they will be persecuted or tortured if returned to their countries of origin. The issue in this case is whether the text of Section 1231A(6) requires the government to offer detained non-citizens bond hearings after 6 months of detention in which the government bears the burden of proving by clear and convincing evidence that a non-citizen poses a flight risk or a danger to the community. It does not. Respondent Antonio Arteaga-Martinez is a citizen of Mexico. He admits that he has entered the United States without inspection 4 times. He first entered in March 2001 and was detained at the border and removed. He re-entered in April of that year. 10 years later, in 2011, he left the country to care for his sick mother, re-entering in July of the following year. The government again detained him at the border, determined he was inadmissible, and removed him. Arteaga-Martinez represents that, after returning to Mexico, he was beaten violently by members of a criminal street gang. Fearing that he would be persecuted or tortured again with the acquiescence of government officials, he re-entered the United States in September 2012. In May 2018, U.S. Immigration and Customs Enforcement, ICE, issued a warrant for Arteaga-Martinez's arrest. By then, he had been living and working in the United States for nearly 6 years and was expecting the birth of his first child. He had no criminal record aside from minor traffic violations. ICE detained Arteaga-Martinez without any opportunity for bond and reinstated his earlier removal order. Arteaga-Martinez applied for withholding of removal under Section 1231B(3), as well as relief under regulations implementing the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment. The Department of Homeland Security, DHS, referred Arteaga-Martinez to an asylum officer, who found that Arteaga-Martinez's testimony was credible and that he had established a reasonable fear of persecution or torture. As a result, DHS referred Arteaga-Martinez's claims for adjudication by an immigration judge in what we have called withholding-only proceedings. Pending these proceedings, however, the government continued to detain Arteaga-Martinez pursuant to Section 1231A(6). In September 2018, after he had been detained for 4 months without a hearing, Arteaga-Martinez filed a petition for a writ of habeas corpus in the U.S. District Court for the Middle District of Pennsylvania. His petition challenged his continued detention without a bond hearing on both statutory and constitutional grounds. Shortly thereafter, in a separate case, the Third Circuit held that a non-citizen facing prolonged detention under Section 1231A(6) is entitled by statute to a bond hearing before an immigration judge and must be released from detention unless the government establishes, by clear and convincing evidence, that the non-citizen poses a risk of flight or a danger to the community. The government conceded that under Guerrero-Sanchez, Arteaga-Martinez would be entitled to a bond hearing pursuant to Section 1231A(6) as of November 4, 2018. 6 months after the start of his detention. Once Arteaga-Martinez's time in detention had reached nearly 6 months, a magistrate judge recommended that the district court grant a writ of habeas corpus on Arteaga-Martinez's statutory claim and order the government to provide him an individualized bond hearing before an immigration judge. The district court adopted the report and recommendation and ordered a bond hearing. The government appealed. The Court of Appeals summarily affirmed, citing its earlier decision in Guerrero-Sanchez. Arteaga-Martinez received a bond hearing at which an immigration judge, considering Arteaga-Martinez's flight risk and dangerousness, authorized his release on bond. Arteaga-Martinez posted bond and was released pending a final determination on his application for withholding of removal, which, as of today, the immigration judge is yet to make. This court granted certiorari. The INA establishes procedures for the government to use when removing certain non-citizens from the United States and, in some cases, detaining them. The section at issue here, 8 U.S.C. Section 1231A, governs the detention, release, and removal of individuals ordered removed. This court has held that Section 1231A applies to individuals with pending withholding-only proceedings. After the entry of a final order of removal against a non-citizen, the government generally must secure the non-citizen's removal during a 90-day removal period. The statute provides that the government shall detain non-citizens during the statutory removal period. After the removal period expires, the government may detain only 4 categories of people. 1. Those who are inadmissible on certain specified grounds. 2. Those who are removable on certain specified grounds. 3. Those it determines to be a risk to the community. And 4. Those it determines to be unlikely to comply with the order of removal. Individuals released after the removal period remain subject to terms of supervision. Section 1231A, 6, does not expressly specify how long detention past the 90-day removal period may continue for those who fall within the 4 designated statutory categories. In Zadvitas v. Davis, the court observed that the statute's use of the term may introduces some ambiguity and does not necessarily suggest unlimited discretion. The court explained that a statute permitting indefinite detention of an alien would raise a serious constitutional problem, noting that it had upheld non-criminal detention as consistent with the Due Process Clause of the Fifth Amendment only under certain narrow circumstances. Accordingly, the court applied the canon of constitutional avoidance and determined that read in light of the Constitution's demands, does not permit indefinite detention but instead limits an alien's post-removal period detention to a period reasonably necessary to bring about that alien's removal from the United States. Subsequently, in Jennings v. Rodriguez, this court considered the text of other provisions of the INA that authorized detention. One such provision was Section 1226A, which governs the detention of certain non-citizens present in the country who were inadmissible at the time of entry or who have been convicted of certain criminal offenses since they were admitted. Section 1226A provides that the Attorney General may detain these non-citizens pending their removal proceedings and may release such individuals on bond or conditional parole. Non-citizens detained under Section 1226A receive bond hearings after the government initially detains them. Relying on Zadvitas, the Ninth Circuit had interpreted Section 1226A to require additional, periodic bond hearings every 6 months, with the burden on the government to prove by clear and convincing evidence that further detention was justified. The court in Jennings disagreed. It held that the meaning of the relevant statutory provision is clear and that it did not support a periodic bond hearing requirement. The Jennings court also rejected the lower court's application of the canon of constitutional avoidance. Earlier in its opinion, the court explained that the canon of constitutional avoidance comes into play only when, after the application of ordinary textual analysis, the statute is found to be susceptible of more than one construction. In the absence of more than one plausible construction, the canon simply has no application. Applying this reasoning to Section 1226A, the court concluded that the canon was inapposite because nothing in Section 1226A's text even remotely supports the imposition of either of the requirements the Ninth Circuit had imposed. The question presented is whether Section 1231A, 6, requires bond hearings before immigration judges after 6 months of detention in which the government bears the burden of proving by clear and convincing evidence that a non-citizen poses a flight risk or a danger to the community. Section 1231A, 6, provides that certain non-citizens who have been ordered removed may be detained beyond the removal period and, if released, shall be subject to certain terms of supervision. This text, which does not address or even hint at the requirements imposed below, directs that we answer this question in the negative. The Jennings court emphasized that the canon of constitutional avoidance is only applicable where a statute has more than one plausible construction. Here, there is no plausible construction of the text of Section 1231A, 6, that requires the government to provide bond hearings before immigration judges after 6 months of detention, with the government bearing the burden of proving by clear and convincing evidence that a detained non-citizen poses a flight risk or a danger to the community. Section 1231A, 6, provides only that a non-citizen ordered removed may be detained beyond the removal period and if released, shall be subject to certain terms of supervision. On its face, the statute says nothing about bond hearings before immigration judges or burdens of proof, nor does it provide any other indication that such procedures are required. Faithfully applying our precedent, the court can no more discern such requirements from the text of Section 1231a, 6, than a periodic bond hearing requirement from the text of Section 1226a. Section 1231a, 6, therefore cannot be read to incorporate the procedures imposed by the courts below as a matter of textual command. Arteaga-Martinez responds that Section 1231a, 6's references to flight risk, dangerousness, and terms of supervision support the relief ordered below. Similarly, respondents in the companion case analogize the text of Section 1231a, 6, to that of Section 1226a, and they note that non-citizens detained under Section 1226a have long received bond hearings at the outset of detention. However, assuming without deciding that an express statutory reference to bond, as in Section 1226a, might be read to require an initial bond hearing, Section 1231a, 6, contains no such reference. A more oblique reference to terms of supervision does not suffice. Respondents in the companion case also emphasize that regulations offer custody hearings before immigration judges for non-citizens the government detains under Section 1231a, 6, because it deems them specially dangerous. They argue that if the statute can allow custody hearings for these individuals, it requires such hearings for those in Arteaga-Martinez's situation as well. Federal agencies, however, are free to grant additional procedural rights in the exercise of their discretion. Reviewing courts, on the other hand, are generally not free to impose them if the agencies have not chosen to grant them. The parties do not dispute that the government possesses discretion to provide bond hearings under Section 1231a, 6, but this court cannot say, consistent with Jennings, that the statutory text requires them. Finally, Arteaga-Martinez argues that Zadvitas, which identified ambiguity in Section 1231a, 6's permissive language, supports a view that Section 1231a, 6, implicitly incorporates the specific bond hearing requirements and procedures enumerated by the Court of Appeals. In Jennings, however, this court faulted the Ninth Circuit for going significantly further than Zadvitas. Jennings did not overrule or abrogate Zadvitas. But the detailed procedural requirements imposed by the Court of Appeals below reach substantially beyond the limitation on detention authority recognized in Zadvitas. Zadvitas does not require, and Jennings does not permit, the Third Circuit's application of the canon of constitutional avoidance. Separately from his statutory claims, Arteaga-Martinez contends that reading Section 1231a, 6, not to require bond hearings when detention becomes prolonged raises serious due process concerns. He points out that outside of the national security context, this court has never authorized prolonged detention without an individualized hearing, before a neutral adjudicator, at which the detainee has a meaningful opportunity to participate. He asserts that the government's interest in denying bond hearings is minimal because such hearings do not require release. And he argues that his status as an individual with a reinstated removal order bears no relation to his dangerousness, as evidenced by the fact that an immigration judge authorized his release on bond. The government responds that regulations directing ICE officials to conduct administrative custody reviews for individuals in ICE detention provide adequate process, at least as a general matter. The government contends that these regulations, which generally require a custody review at the end of the 90-day removal period, a second review by a panel at ICE headquarters after 6 months of detention, and subsequent annual reviews, provide constitutionally sufficient substantive and procedural protections for non-citizens whose detention is prolonged. The government also notes that as applied constitutional challenges remain available to address exceptional cases. We are a court of review, not of first view. The courts below did not reach Arteaga-Martinez's constitutional claims because they agreed with him that the statute required a bond hearing. We leave them for the lower courts to consider in the first instance. Arteaga-Martinez also advances an alternative theory that he is presumptively entitled to release under Zadvitas because, in view of the length of time that withholding-only proceedings tend to take, his removal is not reasonably foreseeable. The government disagrees on the merits and adds that the issue is not properly before this court because it would alter the scope of the judgment below, which granted Arteaga-Martinez a bond hearing, not release. Again, we decline to reach this claim in the first instance. The judgment of the Court of Appeals for the Third Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Breyer, concurring in part and dissenting in part. The government can normally detain persons unlawfully present in, and ordered removed from, the United States for a 90-day statutory removal period. However, Section 1231A, 6, provides that the Attorney General may sometimes hold such a person in custody for a longer period. It says, an alien ordered removed one who is inadmissible to or removable as a result of violations of status requirements or entry conditions, certain violations of criminal law, or reasons of security or foreign policy, or 3 who has been determined by the Attorney General to be a risk to the community or unlikely to comply with the order of removal, may be detained beyond the removal period. In Zadvydas v. Davis, we read an implicit limitation into this provision. Because a statute permitting indefinite detention of an alien would raise a serious constitutional problem, we held that the statute, read in light of the Constitution's demands, limits an alien's post-removal period detention to a period reasonably necessary to bring about that alien's removal from the United States. It does not permit indefinite detention. We also held that the period reasonably necessary to effect removal was presumptively 6 months. We recognize that period for the sake of uniform administration in the federal courts. But after this 6-month period, once the alien provides good reason to believe that there is no significant likelihood of removal in the reasonably foreseeable future, the government must respond with evidence sufficient to rebut that showing. And for detention to remain reasonable, as the period of prior post-removal confinement grows, what counts as the reasonably foreseeable future conversely would have to shrink. In my view, Zadvydas controls the outcome here. The statutory language is identical, which is not surprising, for this case concerns the same statutory provision. There are 2 conceivable differences between this case and Zadvydas, but both argue in favor of applying Zadvydas' holding here. First, the respondent here, Antonio Arteaga-Martinez, has been ordered removed, and is therefore subject to Section 1231A, for a different reason than the persons whose cases we considered in Zadvydas. Kestutis Zadvydas and Kim Ho Ma were ordered removed because they had been convicted of serious crimes. Zadvydas had committed drug crimes, attempted robbery, attempted burglary, and theft. Ma was involved in a gang-related shooting and convicted of manslaughter. Arteaga-Martinez's only crime, besides minor traffic violations, is entering the United States without inspection. The government seeks to detain him while an immigration judge considers his claim that he will be persecuted or tortured if he is returned to Mexico. There is less reason, not more, to detain Arteaga-Martinez without bail. Second, Zadvydas provided for outright release. This case involves a bail hearing. Again, the government has less reason to detain a person when the alternative is a bail hearing, where the government has an opportunity to show that that person might pose a danger to the community or a flight risk, than when the alternative is simply release. The government argues that a later case, Jennings v. Rodriguez, dictates the result here, rather than Zadvydas. Not at all. That later case involved detention under statutes other than the one at issue here and in Zadvydas. The court in Jennings did not modify or overrule Zadvydas, but rather explicitly distinguish that case. It did so on multiple grounds, including the fact that almost all of the statutes at issue in Jennings used words that mandated detention, such as shall, rather than words of discretion, such as may. In Zadvydas, the word may created ambiguity that permitted the court to interpret Section 1231A, 6, the statute before us, in a manner that avoided the constitutional problem that indefinite detention could have created. The majority in Jennings held that the statutory provisions at issue there were not similarly ambiguous, and therefore did not permit the court to reach a similar interpretation. It is true that one of the statutes interpreted in Jennings, Section 1226A, said that the Attorney General may arrest and detain an alien pending a decision on whether the alien is to be removed, or may release the alien on bond or conditional parole. Why did this statute not give the court the textual leeway needed to permit a bail hearing, given the constitutional problem posed by potentially indefinite detention? Here is the court's answer to that question in its entirety. The Court of Appeals ordered the government to provide procedural protections that go well beyond the initial bond hearing established by existing regulations, namely, periodic bond hearings every 6 months in which the Attorney General must prove by clear and convincing evidence that the alien's continued detention is necessary. Nothing in Section 1226A's text, which says only that the Attorney General may release the alien on bond, even remotely supports the imposition of either of those requirements. Nor does Section 1226A's text even hint that the length of detention prior to a bond hearing must specifically be considered in determining whether the alien should be released. The court below did not order periodic bond hearings, but it did require the government to satisfy a clear and convincing evidence standard. I agree that Jennings forecloses this latter requirement. Otherwise, I would find the lower court's bail hearing requirements reasonable implementations of the Zadvydas standard, which is applicable here. Since the court remands this case for further proceedings, I would add that, in my view, Zadvitas applies, the court does not hold to the contrary, and the parties are free to argue about the proper way to implement Zadvitas standard in this context, and, if necessary, to consider the underlying constitutional question, a matter that this court has not decided. Justice Thomas, with whom Justice Gorsuch joins as to Part 1, concurring. I join the court's opinion because it correctly decides that 8 U.S.C. Section 1231a, 6, does not require periodic, 6-month bond hearings. I write separately to make 3 points. First, we lack jurisdiction to hear this case. Under 8 U.S.C. Section 1252b, 9, a federal court has jurisdiction to review questions of law and fact, arising from any action taken or proceeding brought to remove an alien, only in 2 circumstances. 1, when the court reviews a final order of removal, or, 2, when Section 1252 otherwise grants jurisdiction. This jurisdictional zipper clause covers all claims related to removal proceedings, including detention-related withholding of removal claims. Because Arteaga-Martinez does not seek review of a final removal order or otherwise invoke Section 1252, and because his claim arises from his removal proceedings, I would vacate and remand with instructions to dismiss for lack of jurisdiction. Nonetheless, because the court has held that we have jurisdiction in cases like these, and the court's opinion is otherwise correct, I join it in full. Second, as I have explained elsewhere, there is considerable historical evidence that the Due Process Clause does not apply to laws governing the removal of aliens. But even assuming the Due Process Clause extends to some aliens contesting their removability, it does not protect from detention an alien who, like Arteaga-Martinez, does not challenge his final removal order. Illegal aliens deemed removable have no right of release into this country. Although the court properly declines to decide Arteaga-Martinez's due process claim, we should revisit whether the Due Process Clause applies at all in this context. Third, this case illustrates why we should overrule Zadvitas at the earliest opportunity. There, the court held that Section 1231a, 6, would raise a serious constitutional problem under the Fifth Amendment if it permitted indefinite detention of an alien. To avoid that supposed problem, the court deemed ambiguous the statutory authorization that a removable alien may be detained beyond the removal period, and then, clothed in constitutional garb, invoke that manufactured ambiguity to graft a made-up rule onto Section 1231a, 6. Namely, the court decided that immigration authorities can detain an alien only long enough to accomplish the basic purpose of effectuating an alien's removal and must release him once removal is no longer reasonably foreseeable. The presumptively reasonable detention period, the court declared, was 6 months. The court offered no textual support for that, or any, length of time. As we later implied in Jennings, the constitutional avoidance canon cannot justify adoption of such an implausible construction of Section 1231a, 6. And, until we overrule Zadvitas, it will continue to invite nothing but mischief. An ill-defined, quasi-constitutional command of reasonableness inevitably encourages courts to fashion procedural rules with no basis in statutory text. We confronted that mischief in Jennings, and we do so again today. We will be forced to engage in this jurisprudential whack-a-mole until we recognize that Zadvitas was wrong the day it was decided and thus does not warrant stare decisis effect. These 3 points notwithstanding, the court's opinion correctly interprets Section 1231a, 6. Accordingly, I concur. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. If you would like to support my efforts to make Supreme Court opinions available to the public, please go to the podcast's website. It's at anchor.fm/SCOTUS-opinions/support. Again, the website address is anchor.fm/SCOTUS-opinions/support. There you can also see other episodes and send a message to me, the podcast's creator. Thank you.